Welcome to the Melinda Eitzen Show. I'm Melinda. Today we have one of our lawyers from Duffee Eitzen, Devin Kerns.
I'm so happy to be here. Thank you so much for having me.
Thank you for coming.
Sure.
So the legislature met
Yes,
this summer, and they made some law changes that just went into effect recently. September 1, most of them. True?
That's correct.
So this happens every couple of years.
Yes,
We have
some big ones.
We have to stay up. That's part of our job, right? Stay up on the law.
I really like that about family law. I think that, there's a very active, contingency of lawyers and lobbyists, and we're always trying to improve. And it's just a very fluid area of the law because it's very human. So we always have to keep updated on it. And there's a lot of changes recently.
Okay, let's start with child support.
Okay.
Everybody wants more child support except
right.
the person paying it.
That's right. So the big news with child support is that the net resources cap has increased to $11,700 a month, which what this means is the court looks at the net resources of the obligor, and there's a max cap. So you can't just pay unlimited child support if you're making a ton of money. And that used to be $9,200 a month, and now it's $11,700 a month. So that's about a 27% increase.
So when I do the rough math, I think now, if they make $140,000, do you think that's what it comes to?
That sounds right to me. I haven't done the math, but yeah,
ish. If they make more than that, they're gonna not pay more than the cap. And what we mean by paying more than the cap is the family code applies a percentage of their income,
right?
Depending on how many kids they have,
right?
So let's just, as an example, if they had 2 children, what percentage of their income are we applying?
So we're applying a 25%.
And if they make less than $11,700 net a month, it's whatever the number is. So let's say the person makes $5,000 a month. They're going to pay 25% of that in child support.
Right. And I find that most of the time, my cases, we'll have one child that we're dealing with, and that's 20%. I think a lot of people don't realize it's that high of a percentage. So that means the max cap that you're going to pay is $2,340 a month for one child. And I think it's interesting. It can sound like a lot, but we were just talking before this, and with inflation and prices of everything going up,
yes,
it's really not. So I think this is a really good thing.
So to add to this, so people understand, if somebody is making $100,000 a month instead of $11,700, the 20% still only applies to the $11,700.
Yeah, the first $11,700.
So that's where it starts to feel to people maybe not fair, right? Is if you have a really high wage earner. Now, they could do something by agreement. They could pay more by agreement.
Yeah, and a lot of times people will want to get rid of any sort of child support if they come to an agreed order and they say, I will agree to pay for this category of childcare. Maybe you have a specific daycare or private school the child is attending, and you can reach agreements on how all of that stuff is going to be paid without going through the child support whole formality process. And it's really, you can tailor it to what your situation is, but if you're going to get formal child support, these are the numbers we're talking about.
It's a math equation.
Yeah.
So every 6 years, the family code says this can be reassessed. It seemed like more than 6 years to me. I wonder if it was, but we finally do have a little increase. So that's good for the higher wage earner people.
Yes, and I will point out that I don't think that just because this increase has taken effect, you can go in and change child support. Now, of course, you can point to that if you have a modification that you're wanting to file, but in general, I don't think it's correct to go in and just say, hey, the law's changed my child support. You're still probably going to have to show the other grounds for modification, but it is something definitely to know if you're thinking about modifying the previous custody order.
Well, one thing that people should know is the Attorney General will do it for free. The Attorney General will review child support for free for anyone in Texas. You don't have to qualify financially or anything. So it doesn't hurt to ask. I mean, they might just be saying, hey, the law's changed.
Yeah.
We don't know. It just went into effect. But it will be interesting to see what happens. Okay. So that was not our only important law change.
That's right.
let's talk about some others. This has been a trend that there's been a change in protective orders.
Right.
And this isn't the first one. We had one in the last legislative session before this. And they seem to be trying to protect people more who have been victims of family violence.
Yeah. And of course, I don't think anyone can disagree that that's a good thing.
Right.
And, I just think that it's such an unusual emergency situation. I know that when I've had to do protective orders, it's always just the very nature of the filing is kind of chaotic because something really bad has happened, violence, there's injury.
Mm-hmm.
A lot of times the police are involved. And so when you're rushing, running to the courthouse, preparing this filing, running to the courthouse, it matters to be informed of what the law is. So everyone's on the same page.
Mm-hmm.
And I do think that this is, it can be pretty technical. So I do think the legislature is trying to emphasize the importance and get the correct attention paid to these kind of filings because these are the most emergent situations.
Right, absolutely. And people can hire a private lawyer to do it, but in some cities, the district attorney will do it. They just go apply to the district attorney. They have to go usually in person and fill out a form, and the district attorney can do it. But sometimes people hire lawyers to do it like us, and we're honored to help.
Mm-hmm.
And sometimes they're adding it to another filing like a divorce.
Right.
And the DA isn't going to handle your divorce.
Right. And one of the changes is that a protective order is expressly prioritized over a suit affecting parent-child relationship or custody suit or a divorce order. So I think that's a good thing. And like I said, these are the most emergent situations, so they should be prioritized. And now there's an automatic duration extension that will extend a protective order for 2 years if you have a SAPSR, suit affecting parent-child relationship, or a divorce case. And the parties have to generally be involved both in the protective order and in the underlying SAPSR divorce order. So that I think is helpful because instead of having to run back to court to ask for an extension, to ask for the protective order to last for 2 years, it just automatically gets extended. So I think that's really helpful.
And normally, if you applied for a protective order and you got one, the general term was 2 years, but it didn't have to be, correct?
I believe that's right, yeah.
And now you're saying if they reapply or ask for it to be extended, it would be automatically extended for 2 years.
Yes, and I think that is that just makes sense. And I don't think anyone's fighting this, but it's like a cleanup point.
Yes, well, I think the legislature has recognized that when people are going through a divorce or litigation, a SAPSR, meaning they were never married, but they had children together and they're fighting about it, that can be a hot fire point. That itself makes things a little more dangerous. And if we're going to have a danger point, we want to be cognizant of that.
Right.
So I think they're protecting about that. And I think the last legislative session before this one, they changed it so that the burden of proof was different. So you had to show that something happened, that met the definition of family violence. But used to, we had to show and that it's likely to occur in the future.
Right.
And they erased that.
Right.
You don't have to show it's likely to. How do you show something's likely to occur in the
Right.
future, for one?
Right.
Challenging burden to begin with. But now they've eliminated it. So if you show the violence one time, done.
Right.
You get a protective order.
No, and I think that's right. So it's really whether family violence has occurred. And you think that's simple, just talking about it in the abstract like we are now. But in reality, it can be a little bit more complicated. We see a lot of situations that maybe there's a scuffle over a phone, and maybe there's no overt injury requiring hospitalization or an emergency room visit, but it's still not, it's still violent, kind of. Anyway, so
how do you definition?
Right.
Taking someone's phone and not allowing them to call for help,
right.
That is family violence.
So, I mean, I feel like that is the most common situation I see is there's something on a phone, someone's trying to get to or hide, and there's an altercation.
So our advice is don't fight over the phone. Like, just let the phone be. We can get the phone in litigation if it's really important.
It is really not worth having a protective order filed. Like,
Right.
you
Not fight over the phone. Let them have it, or let them look at it, or don't try to look at it, whoever you are in the scuffle.
right.
My experience has been that family violence without intervention escalates over time.
Mm-hmm.
And it typically starts, and people don't think of this as violence or family violence, with grabbing, restraining, like not letting someone leave a room. They're saying, no, you're going to stay here and talk to me about this. Pushing. And then it goes from there to something more serious. But you'll often see the bruising on the arm where they've grabbed the person. But you don't have to leave a bruise for it to be family violence.
Right.
Correct? But to your point, it's not always dramatic.
Mm-hmm.
They didn't have to push you down the stairs and you broke 3 bones for it to be family violence.
Right.
And anybody listening who is in a situation where they're being restrained, they're not being allowed to use their phone, they're not being allowed to leave a room, they're having a 2-hour fight in the middle of the night, they need to either get serious intervention, meaning let's get therapy and, have something happen, or they need to get out.
Right.
Because those people, they obviously can't control themselves in it, and it escalates, and eventually they'll kill you. I mean, that's what could happen.
And I would point out, I mean, this is not a new update, but that is the way to kick somebody out of the house is through a protective order. Much harder to do that in a divorce or SAPSR case. Really, the mechanism to do that is getting a protective order against somebody, which requires family violence findings. So that's the way to go if you're in one of those situations.
In that situation. And get advice. You can go to the DA and they'll give you advice, but an individual lawyer can advise you. You're trying to weigh, is seeking the protective order going to make it better or worse? But typically you need the protection. And what's nice about it, even though it is just a piece of paper and somebody can still come kill you, right? So you need to take precautions. You need to take common sense precautions. It does alert authorities that something bad is going on with this person. And if they're a rule follower at all, it might solve it. They might stay away from you. So people do need to measure all of that. Yeah. And to your point about the kick-out order, you can get a kick-out order with protective order. The only way to get someone out of the house without a kick-out order is to have a hearing, a fully contested, if they don't leave by agreement, fully contested hearing, and then ask the judge after that temporary hearing, hey, I want sole exclusive use of the house. The other person saying the same, and the judge decides. Right. That takes a little longer.
Especially if you have a busy court docket that it'll be a month before you can get a hearing.
Exactly.
And if you're in an emergency situation, you need someone to get out.
Yes.
That's the way to go.
It's also fine to be the one that leaves. I find that sometimes people don't want to leave the house, but if you're a victim of domestic violence, they know where you live.
Yeah.
So sometimes it's better to be the one to leave so that you can be someplace where they cannot find you.
Yeah.
So I totally agree. I'm not hesitant to say, just get out. Get out.
Yeah. I mean, safety is the main. You can't get your, financial divorce situation under control until everyone's safe. So.
Yes. Safety first.
Absolutely. And the only other point I'll make about protective orders is there's a mandatory transfer with a safety exception now. Before a transfer to a divorce court or a court of continuing exclusive jurisdiction was discretionary, and now it's mandatory, provided the court finds the transfer will not negatively impact the safety of a protected person under the protective order. So it's a similar procedure to existing transfer statutes in that it requires a controverting affidavit from the person resisting transfer that it would have a negative impact on the child.
And you're talking about transferring it from court A to court B.
Correct.
Because when you file the protective order, it's not going to necessarily be in the same court the divorce is in.
Right. It may not be, and it may be, but everybody needs to be in the same court. That's typically the best outcome under the way the law works, just in general. All the parties to a divorce or a SAPSR suit should generally be talking about the same thing in front of the same judge. That's the way pretty much everything is conceptualized.
More efficient.
It's a little more efficient. So I think that this is, again, kind of a cleanup point that makes a lot of sense. So
you talked about how the law has developed in family law because, we're dealing with people, and we have 2 ways that we have laws, right? We have statutes,
Right.
which is what we're talking about. But then we have case law,
Right.
where the court rules on something. And sometimes after a time, the statute will match the case law, how the
Right.
case law has developed
Right.
through the courts. When I started practicing family law, the family code was now
Oh yeah.
it has grown.
I mean, it's a tension between judges interpreting the statutes, right? And
Yes.
then the legislature responding, maybe not liking what a court
How
has
they
said
interpreted it.
and responding. So there's a push-pull there, which I think is what makes the law really fun and interesting. It's always changing. It's not always the quickest to change.
Yes.
But
And sometimes, since I've been practicing, which is 31 years, the legislature will change something. We all hate it. Like it wasn't a thoughtful change, or, the legislators were not family lawyers.
Right.
They do have family lawyers come testify about the changes, but sometimes they'll apply a change to us. And I can think particularly about some discovery changes, which is how we go about exchanging information. And maybe they're changing us to match what the civil people are doing, civil courts, and it doesn't really make sense for us. And then the next session they fix it because there's such an uproar.
Oh yeah,
of lawyers saying that is not working for us.
Family law is such a unique such a unique practice because it is very niche. It is civil in nature, but we do overlap with criminal matters. And I always kind of liken it to bankruptcy law or something where you've got your own code, but we're still expected to comply with other areas of the law that are in the civil realm. But there's different needs and there's different expectations, and litigating within a family is very, very different than litigating between business partners or whatnot. So,
or the government and,
right.
and an entity or two companies.
Right.
Yeah. No, it's a different world.
There's different needs.
Okay, let's talk about non-parents who want your child.
Oh, yeah. This is a huge, huge change that a lot of people are talking about because...
So first lay the groundwork. Like, what are we talking about? Who are non-parents? Give an example.
Talking about step-parents.
Okay.
Right? Grandma, grandpa, aunt, uncle, people that have maybe taken in a child while bio mom or bio dad, if bio dad's not in the picture and bio mom is in rehab, or, insert any number of life situations where someone cannot take care of their child, or they've remarried and there is we're talking about a non-biological, non-adoptive parent being in a child's life.
So it could be hey, the mom or dad dumped the kids with his parents,
right?
Or her parents, because they had to go take care of something, or they just wanted to go find themselves in California.
Right.
It could be they were drug alcohol user and they at least recognized they couldn't take care of their child. So they got their sister and their sister's husband take care of the child while they went and did drugs. But at some point that parent gets it together maybe. And now they're back and they said, hey, I'd like my child back.
Right.
Well, now that non-parent has a parent-like relationship with that child.
Right.
Or different scenario, they haven't been dropped off. This non-parent hasn't had the child, but the non-parent sees that things are bad, that the parents are using drugs, not taking care of their kids,
right?
And somebody needs to do something. So they're trying to step in and say, hey, you're not doing right by my grandchild or by my niece, and I want that child. And you need to go get your what together.
Right. Or, they have the child and that there's a school or some other institution that's needing a formal order in order to, enroll the child in school, and they can't do that because they don't have formal conservatorship. So there's a number of reasons why you would want a court order.
And the push-pull is, under the Constitution, parents feel like they should have a right to do whatever they want with their kids.
Right.
So it has to rise to a level that it really isn't good.
Right.
I had an interesting case once where the parents weren't totally, it wasn't an extreme situation of, just test them for drugs, right? But they were just kind of a little wacky. And they were doing some wacky stuff. And they were doing it like up at the school in an embarrassing way, like doing weird stuff in in the carpool lane, like going up to all the
Right.
cars, like trying to maybe sell an idea.
Yeah.
Like they kind of were wacky.
Right.
And so the grandparents tried to come in and say, you're doing weird stuff, and I don't want my grandchildren raised in that. And so the court has to decide, is it crazy enough?
Mm-hmm.
Okay, so what does the law say about these non-parents? What direction is the law going?
There's kind of two, for non-lawyers, there's a concept called standing, which you have to have to get in the door of the courthouse. If you're a parent, you clearly have standing to have a custody suit over your child, right? But that's kind of the hurdle, the first hurdle that these individuals face. If you're not a bio or adoptive parent of a child, you have to meet specific requirements to even file a lawsuit and file a custody suit.
So some stranger couldn't come say, I think I could do a better job.
Exactly. And so they made some changes. The legislature changed the standing statute for non-parents. And one of the big changes was, before, it used to be you could have standing if you had actual care, control, and possession of a child for 6 months, and they changed the word actual to exclusive. And now everyone's like, what does that mean?
Okay, well, let's talk about that for a minute. So you could totally see, in this economy, things are getting more expensive. You could totally see a single parent and their child moving back in with her parents, right? I'm going to use a woman as an example. So let's say she's like, hey, I can't afford that, my apartment rent just went up. I'm going to go move back in with my parents. Mm-hmm. But in my little made up scenario, not a drug user, not a bad person, just lives with her parents for 6 months with the child. Before it said exclusive, she just gave her parents standing to file a lawsuit. That doesn't mean they would win, if she's a good person, but they could at least come in the door.
File a custody suit against daughter, correct?
So the legislature said that isn't what we're talking about. It has to be exclusive. It has to be, I dropped off my kid to my parents and I went to find myself in California.
Right.
Or across town.
Right. So I think, this is what will happen in a legislature. They use words. They try to be as exact as possible, but lawyers are paid to they're paid to advocate for their client. And if daughter is living with grandma and grandpa want to file a custody suit, maybe grandma and grandpa's lawyer is going to say, what does exclusive actually mean? And let's try to fight about what that could mean. Interesting point that I heard at a presentation that I just attended was, could you argue exclusive to the other parent? So, for instance, if you had a divorce situation and you had a step parent or some other relative that was sharing a custody schedule with a possession schedule with the other parent, could you say that I have had care, custody, and control, care, control, and possession of the child exclusive to the other divorced parent? Or do they just not get in the door at all?
Oh,
interesting argument there.
And so what will happen now is the new laws are in place.
Yeah.
Push go. We're going to start litigating about them. And then the courts have to start interpreting what they think the legislature meant, or they decide, oh, no, it didn't mean that, or it did mean that. And that goes on for a while.
Oh, yeah.
And then the legislature might come back in a few years and say,
well,
no, that isn't what we meant.
It takes time for cases to reach a court of appeals, because really when we talk about case law, we're talking about court of appeals decisions.
Or higher, right?
So trial courts will make decisions every day, but for someone to spend the money and pursue a custody case all the way up to a court of appeals or the Texas Supreme Court can take even more time.
Yes.
But I will say overarching changes are very, very focused on the parents with this update. It's a
giving the parents more rights.
Right. Yeah.
And keeping the non-parents at bay. Like, you really better have something.
Right. There's also a change where there used to be, they called it the step parent statute, where if a parent is deceased, there was non-parent standing, and they completely deleted that provision from the standing statute.
So in our scenario, mom's alive, dad was married, he dies. And used to, his wife,
that mom
did come in and fight.
Correct.
Not anymore.
Right.
She's a non-parent.
Right.
I think that what's good about this in helping the parents is sometimes standing doesn't mean you win.
Right.
But if you can get in the door and cause a lawsuit, people have to pay a lot of money to defend themselves. And that alone could cause some parents to not really have a good chance at fighting.
Right.
So what I like about this is I think it's narrowing it to a true need.
Right.
They're not going to go harass people unless there really is a problem with that parent.
Right. I do think, I mean, a good point that I've heard recently is a step, if you're in a same-sex relationship, right,
Mhm.
and you, if a bio parent passes away, really the other parent that's been functioning as a parent, even though they might not be the biological parent of the child,
Mhm.
what do you do in that situation if, you know, the
They've
donor
got
is
to
not
adopt.
involved?
They've got
Right.
to adopt at the forefront.
Right.
So before they had standing,
Mhm.
and they don't anymore.
Right.
So it's really going to force that adoption at the forefront.
Right. So, and you can argue many different situations with these, but it's clear that there's a preference to favor the parents in these legislative updates. Now, additionally, a non-parent that's intervening in an existing suit affecting parent-child relationship has to file an affidavit describing that denying that the relief that they're seeking would significantly impair the child's physical health or emotional development. And this is referred to as the fit parent presumption in our line of work. And this basically is another procedural hurdle that the legislature is communicating to litigants. You have to basically give the judge a preview of the merits of your lawsuit, saying this is why you should give me possession or conservatorship rights. And now it requires dismissal, and it's going into effect right now. So if you have an existing case, it's not just applying to cases that are filed after the September 1 deadline. It's applies to existing cases right now. So
That's interesting.
get your affidavit on file, or else you might get dismissed.
Yeah.
Um,
And if you're the one who's fighting against the non-parent, file your motion to dismiss.
yeah, exactly. But I do think that's interesting because it also, when you file your affidavit, the statute says it can be made on your personal knowledge or on representations made to the non-parent, which is hearsay. So I don't know why they decided to go that route, but it's interesting.
It's loose.
It's pretty loose.
Yes. Well, that's interesting.
Yeah.
Well, it's not the end of the lawsuit, right? So it's just kind of there. We just need to show you, Judge, that at least what we say we think is the problem sounds like a real problem.
Right.
And not my little scenario where they're acting a little wacky.
Right. And I think one of the other good changes is, so beyond standing, you get to the merits of the lawsuit, right? So if you've met standing, you're in the lawsuit. There was a big case called Troxel that described overcoming what courts refer to as the fit parent presumption, which is the presumption that if you're a parent, you're acting in the best interest of your child, and you have to show that you're unfit, which is kind of a low bar. But there was an open question in the case law before where it was kind of what burden of proof do you need to meet to overcome the fit parent presumption? And the legislature has made clear that it's clear and convincing evidence, which is a higher burden than the preponderance of the evidence, which is common in civil cases generally. So the legislator has communicated, once again, a preference for parents.
Yes. Well, that doesn't sound bad.
No, it doesn't. But I think
as a parent, I kind of like it.
Yeah. And one of the things they also made clear is a non-parent can't overcome that presumption by just pointing to a prior agreed order that maybe they had a previous case between the parent and the non-parent, and they all came to an agreement on custody and conservatorship or possession. And so now they can't just say, oh, well, we're already in. And so I overcome the fit parent presumption. No, the legislature had made clear, no.
What's kind of nice about that, it allows a parent to go take care of themselves if they need to go to rehab or something. They could still put an agreed order in place, allowing the grandparent or whoever it is to go enroll the kids in school, get medical attention while they're at rehab, and not have that held against them.
Right.
So I can see the point of that. That's kind of a attractive.
But if you have a modification of a prior agreed order, I an open question that I think is interesting is you, as a non-parent, would need to go earlier before that prior order was entered and maybe point to usually
the behaviors that led to it.
Right. Usually you can't do that in a modification, but with this change, I think there's a good argument that you could say, I need to look at evidence and facts that happened before that prior order was entered to show that I do overcome that. Fit parent presumption.
Yeah, it's interesting. I had a client call since we've had for years going grandparent rights were just being reduced. So we're still on that path based on these changes. And I had a woman call me and she's mad. She's a grandparent. She doesn't approve of some of the parenting decisions of her daughter or son. And she wanted to go sue him. And I said, based on what you're telling me, you are not going to win. So you need to find a different approach than suing them. You need to go be their friend. Like, be super nice, because you have the risk of losing access to your grandchild.
Right. Yes.
Cutting off a grandparent is not give them standing.
Right.
It would be very difficult the fit parent means, as a fit parent, I have a right to cut off relationships to my child if I think that's the best thing.
Right.
Maybe you're a horrible, mean grandparent.
Right.
So I was counseling that person, do not sue them. Go figure out how to be their best friend so you can at least influence the child when you're with the child in a positive way. You can have some influence if you're in their life. You're not going to have any influence if you sue them and lose because you can't even get in the door of the courthouse, and now they cut you off.
I think that makes the most kind of utilitarian sense, that the court is not interested in getting into the personal decision making of a parent, right? You have to really show they are unfit as a parent. They are doing real bad stuff. And otherwise the court's just not interested in kind of litigating the personal decision making.
Yeah, they can't micromanage everybody's household.
Right.
Did you give him the best bologna sandwich, or is bologna unacceptable?
Right.
No, don't care.
Right.
Give him bologna.
Right.
I don't personally care for bologna. A simple example. Okay,
Absolutely.
well, we're almost out of time. Let's just touch real quick on enforcement.
What else? Okay. So there's a 3 strikes provision.
This is new.
If you have 3 prior contempt findings for violating a possession and access order, the 4th finding constitutes a material and substantial change, which is grounds for a modification. And also, the 4th finding requires commitment to jail.
You're going to jail.
Yeah.
So they have not followed the order. There's already an order in place.
Right.
And it says, I get the child on the first weekend, and the other person does not give me the child for the weekend. Just because they don't want to. Right. They're busy, whatever. They're ignoring the order. And if I file an enforcement, go get the judge to say, you're right, they violated the order, I'm holding him in contempt. Then if I can make that happen 3 times, I might be able to, just based on that, get in the door on a modification to change the order.
Right.
If you're not going to honor my time, then I need another order.
Right.
And it also means you're going to jail. That's a big deal. I think it's going to increase litigation, because I think people are going to say, oh, well, I want to have a modification. Right. That's not the only way you get one, but it is one way to get one.
I mean, we were talking earlier, it begs the question of, oh, you didn't let me have the child for an entire weekend, but what about you were 15 minutes late to an exchange? Right.
If people sue each other over being 15 minutes late, judges are not going to like that. No. Don't do that.
But there's a lot of, I think the point is there's a lot of custody orders are huge. There's a lot of ways to violate them. And so if you're the parent that's trying to catch the other parent and activate this provision, there's a lot of angles to take. Now, I will say, criminal contempt requires a finding of willful intent, right? So
yeah, they had to mean to do it. They weren't just, people do get confused sometimes, and that should be, you shouldn't sue somebody that you haven't called and said, hey, it's my weekend.
Right.
It's the 5th weekend. I was confused, whatever. Yeah, you don't just let it go by and then go.
I do think judges are very cognizant of that.
Try to act right. Oh, Devin, thanks so much for being with us.
Of course.
It is so interesting to keep up with the law. It keeps us from getting bored, for sure, right?
Oh, yeah.
And it's important for people, if they are looking for lawyers, to find ones that actually follow what is happening in the changes.
There's a lot and they're important. And, but anyway, I've had a great time here with you this morning and thank you
so
for having
much.
me.
Oh, we really appreciate it. Thank you so much for watching. Stay up on the law. We will keep you informed. We'll have 2 years before we have more changes unless something dramatic happens out of the Court of Appeals or the Supreme Court. But thank you for watching and please tune in again.